Let's shift focus and talk about another developing story, which is regarding the DHFL resolution, the debt resolution. What has happened this morning is there are reports coming in that one of the, of course, large mutual funds which had a small exposure to DHFL has initiated, court proceedings and litigation and legal recourse on their 169 crore exposure. We are talking about DSP mutual fund. So Ashvin Parekh is here on the phone line to help us understand, though which appears small, can this litigation have a, overall cast a shadow on the entire debt resolution plan which is undergoing right now? Mr. Parekh, there is a concern in the market that it may happen. And of course, some of the private equity players which were keen to pick stake, they also may turn shy now, seeing that some litigation is starting once again. What are your thoughts on this?
Yes, so I mean, see, there are two, ways in which one can really look at this. One of the ways in which, let's say, the whole thing has to be looked at is that, let's say, if DHFL is a going concern, I mean, and in the normal course, if there is an acceptance, that the exposures, particularly the loans to the real estate developers, for instance, those are the only ones where there can be a bit of a valuation issue or a price discovery issue. The rest of the portfolio seem to be having some value there, good value there. So if that is the belief, then the size of the haircut can always be, almost be estimated somewhere around, 60% or whatever for the financial lenders. With this development now, we will have to really examine two things will get challenged. One is, can we still continue working under the premise that it's a going concern? Then in that case, if there is a legal sort of proceedings against the entity. And the second one, of course, is in the waterfall matter also, till I suppose the amendment in the Act happens, basically, we may have to see how exactly the rights of, that is the participation in the waterfall, what is the new amendment, how does it really work out, and things like those. But this is an interesting development. I thought, that since different security holders or unsecured lenders will have different level of, let's say, security rights, backed up by the security, that is, I mean, then in that case, the waterfall treatment may vary and some of them may perhaps not like it and jump the gun and take legal kind of a process.
Just one follow-up, Mr. Parekh. When we reached out to DSP, they said that, the sources in the company said, or their legal advisors, that, look, we just want to ensure the protection of the investor. We already, taken a hit on our books, though. But in some manner, if we could recover it, it will be good for us. But at the same time, we don't want to, put a spanner in the works for overall resolution, because it will jeopardize a much larger good, which is just about to happen if a resolution plan is accepted by the committee of creditors. So that was their reaction. So what are your thoughts on this?
Well, I mean, there are ways in which, let's say, that at least that part can be covered. I mean, to the extent that they could have really participated in the ICA process, the inter-creditors kind of an agreement or let's say, mechanism or a platform. They could have really done that. But then, of course, if any one of the lenders or any one of the creditors believe that the right may be jeopardized, in the final recovery or in the final resolution, then of course he has a right. I mean, you cannot deny that. The process will have to then, in the due course, really attend to that as well, I would say.
Thanks,
but
Mr.
between the said intention and the real intention, I mean, there must be a bit of a gap. I'm seeing a bit of a gap there.
Okay, Mr. Parekh, great chatting with you. Thank you for helping us understand how the scenario is playing out and sharing your insights on it with us.